de la fonction. L'autre fonction, c'est la fonction de contrôle de l'action gouvernementale. Et là, dans l'intérêt du temps, c'est tout ce qu'on fait au niveau national. Il y a des rapports que l'exécutif doit apporter pour analyse et débat par l'Assemblée. Nous avons le rapport des activités annuelles, nous avons le rapport d'audit, nous avons le rapport de la coordination de la politique extérieure des États. Ça, c'est au niveau du contrôle des choses gouvernementales. Et nous avons aussi des activités où on va dans les États partis pour évaluer l'état d'avancement des projets régionaux et produire un rapport et des recommandations aux partis concernés. La dernière fonction, c'est la fonction de représentation du peuple. Et là, nous disons que, étant une assemblée régionale, il est très important qu'on garde le contact avec le peuple. Et cela se fait au niveau de deux voies. La première voie, c'est que l'assemblée va vers le peuple, mais et aussi donne accès au peuple pour que le peuple puisse, d'engagement direct avec les groupes organisés, mais et les autres, le peuple peut accéder à l'Assemblée à travers des pétitions. Et nous avons déjà considéré un certain nombre de pétitions. Excellence, monsieur le modérateur, dans l'intérêt du temps, je peux m'arrêter ici et je serai disponible pour répondre aux questions ou même distribuer une présentation plus détaillée par rapport au résumé que j'ai fait. Je vous remercie de votre attention. On applaudit encore. Monsieur le modérateur, comme j'ai le privilège d'être avec le président de l'institution qui m'avait donné confiance pour le présenter.
Enchanté, président.
Il va donner d'autres clarifications avec votre autorisation.
Okay, merci.
Good afternoon. Thank you very much, Dr. Nahayo. You will forgive my voice. I have a bit of cold, so it will not be coming out clearly. So, I've been introduced. My name is Martin Ngoga. I'm the current speaker of the East African Legislative Assembly. I'm happy to be here, and I thank you for a good reception we have had since the time we arrived. The East African Legislative Assembly is profoundly honored that it is going to be the first organ of the community to receive the representatives of the newest member of the community, the Democratic Republic of Congo. And we are prepared to receive the representatives from this country. The assembly has been introduced to you by my colleague. So I requested for this opportunity to perform just one small function. It's a requirement of the law. The administration of the East African Legislative Assembly Act, that before a partner state elects their members to the assembly, the clerk of the assembly must send a notice to a partner state to announce the vacancies and to give a go-ahead for a partner state to elect their members. We already sent this notice to other partner states. We hadn't sent one to DRC. And each partner state is allowed to elect members within 90 days before the expiry of the present assembly. So it can be now or tomorrow, but it cannot be beyond December 18th. So it can be done between now and December 17th. So, Mr. Speaker, I came with this notice, and I want to hand it over to you so that you can start preparations to elect members that will represent your country to the regional assembly. Very quickly, let me also mention that the Regional Assembly is a fully fledged parliament. Those who are elected to join it do that as a full-time job. It is not a part-time job. And the reason it is like that is to allow the Assembly to fully focus on the functions of the Assembly and not be distracted by other functions. So our model is like the European Parliament. We are not like SADC because we are a fully fledged parliament. So those you will elect, and that's one reason why they are not supposed to be members of the home parliament, they are going to be doing that as their full-time job. So, Dr. Nahayo, where is the notice? Mr. Speaker, I want to invite you to come forward so you can have this communication from the clerk that opens the doors for you to start preparations to send your representatives to Arusha. And because in doing this you will be guided by the treaty, Dr. Anatoli said that when you do it wrongly, there are very alert citizens who will be ready to go to court and challenge the way you did it. So, and we will be available to come and help. Let me mention this. When the Republic of South Sudan sent their members, the procedure was not properly done, and we had to do it again. So we are willing to be back here to help you to make sure that the process is properly done according to the law of the community. So I will give you the copy of the treaty so that you do it the right way. And of course the envelope, because there are so many documents. So we are looking forward to welcome you to Arusha, and all of you, I believe, can be candidates. Maybe some of you will be coming as members. Thank you very much, and God bless you.
On applaudit encore l'honorable président. Merci. Je vais faire une brève introduction pour que le premier vice-président de l'Assemblée nationale congolaise, le professeur Mbata, puisse prendre la parole. Honorable président, la philosophie de la rencontre, de cette rencontre de la communauté de l'Afrique de l'Est, c'est en somme un échange d'informations. C'est comme un étudiant qui arrive à l'université, il est bleu. Il ne sait pas comment ça fonctionne. Et nous, on a pris un train donc en marche. Eux, ils viennent nous expliquer comment ça fonctionne. C'est-à-dire, vous verrez pour chaque présentation, il y a d'abord leur exposé et puis notre réponse. Alors maintenant, je vous invite pour que vous puissiez, vous n'avez pas eu le temps de prendre toute l'information, mais nous, l'essentiel vous a été donné. Comment est-ce que la République démocratique du Congo, à travers son Assemblée nationale, entend intégrer cette communauté au niveau de l'Assemblée régionale? Je vous invite donc à prendre la parole. Merci beaucoup.
Honorable président de l'Assemblée législative de Comesa, honorables députés, sénateurs, distingués invités, tout protocole observé, je voudrais d'abord, au nom de l'honorable Christophe Mbosoko Diapwanga, président de l'Assemblée nationale de la République démocratique du Congo, vous remercier d'avoir choisi ce moment pour nous visiter en République démocratique du Congo, et je vous souhaite la bienvenue dans notre pays. Je commence par rendre hommage à son Excellence, M. Félix Antoine Tshisekedi Tshilombo, président de la République, chef de l'État, qui n'a pas hésité un seul instant à nous connecter à la communauté de l'Afrique de l'Est. Parce que, comme vous le savez, la RDC est le cœur du continent africain, et cette communauté qui nous relie à l'ensemble du continent s'inscrit, l'adhésion donc à cette communauté s'inscrit en droite ligne des impératifs constitutionnels. Je ne veux pas être très long, je vais être assez bref pour dire que dans la même logique tracée par le président de la République, nous, Assemblée nationale de la République démocratique du Congo, nous sommes prêts à intégrer le Parlement, l'Assemblée législative de la communauté de l'Afrique de l'Est. Nous sommes prêts à intégrer cette communauté. Comment nous allons le faire? Nous allons le faire à travers notre règlement intérieur, mais nous ne pouvions pas le faire sans avoir reçu les documents qui viennent de nous être présentés. Nous attendions donc formellement cette invitation pour commencer le processus d'adhésion à l'Assemblée législative de la communauté. Donc, dès le moment que nous avons cette invitation, nous allons travailler au niveau de l'Assemblée nationale pour voir comment élire nos représentants. Et bien sûr, je peux vous assurer que nous allons le faire en respectant le traité pour ne pas tomber dans le même cas que le Soudan du Sud. Donc, soyez assurés pour cela. Pour le reste, donc, nous allons le faire au niveau de l'Assemblée législative. Permettez-moi de dire quelques mots en anglais. Dear Speaker of the Legislative Assembly of the Economic Community of Eastern Africa. The first thing to do was to welcome you to Kinshasa. So please feel at home. We are very much pleased that you have chosen this moment to visit us in the DRC. I also had to pay tribute to our President, His Excellency Félix Antoine Tshisekedi Tshilombo, who didn't hesitate to get us integrated within this Eastern African community. Because in terms of our constitution, we cannot move forward in the DRC if Africa is not integrated. So that is a part of our commitment, constitutional commitments, to be part of the continent. So we are ready. I'm standing here on behalf of our Speaker, Honorable Christophe Mboso Kodatwanga, who is not around, but I've been mandated to be part of this assembly. So now that we have got this invitation, we will start. We will start within the National Assembly to make sure that representatives to the Legislative Assembly of COMESA from the DRC are elected in compliance of the COMESA Treaty and in compliance of the procedures. So I want to assure you that now that we have got this invitation, we are going to start the process to ensure that by December, within the 90 days as required, we elect the representatives of the National Assembly of the DRC to the Legislative Assembly of the Communauté of East African States. Thank you very much. Je vous remercie.
On applaudit encore le président. Honorable Président, vous n'aurez pas, je sais que vous êtes très pris, vous n'aurez pas le temps de répondre aux questions. Est-ce qu'on peut déroger à la règle pour qu'il puisse répondre à une seule question, s'il y en a? Si question il y a, parce qu'il doit partir. Alors, merci beaucoup. À voir la salle. C'est que nous sommes d'accord avec lui, on peut les libérer, ok? En attendant, excusez-moi, Président. En attendant, je vais inviter celui qui doit intervenir à la présentation numéro 8, parce que le numéro 7 n'est pas prêt, d'après ce qu'on m'a dit. Il viendra après. Fonctionnement des organes de la CAE, création de l'institution chargée des mines, de l'énergie et de l'environnement et intégration de la langue française. Nous invitons le représentant de la CAE à bien vouloir prendre la parole. Madame est là? Il vient après, d'abord le représentant. Il n'y a personne. C'est le souhait du Congrès, il n'est pas prêt. Alors, vous permettez, nous allons accorder la parole à la personne qui est disponible. Madame, vous allez monter comme ça, vous allez vous présenter. Il va nous parler de la Cour de justice de la CAE. C'est bien ça? Ok. Madame, vous me dites beaucoup de choses. Oui? Oui.
Thank you so much for this opportunity.
Nous excusons pour ce flottement. Nous sommes toujours à la présentation numéro 7, donc directement en ancienne après les 6. On va passer la parole à madame qui va nous parler de la Cour de justice de la CAE. Madame, vous voulez vous présenter, puis vous avez la parole.
Good afternoon, Honorable Speaker of the East African Legislative Assembly, the Principal Judge, East African Court of Justice, distinguished members of the ministries represented here, fellow East Africans, good afternoon. My name is Wanjiro Rubia, and I will quickly take you through a few key points concerning the East African Court of Justice. We will look at who we are, what we do, and a bit of how the court works. I'll try and keep it brief. If you look at Chapter 8 of the treaty establishing the East African Community, you will find a whole chapter dealing with the court. The court has been in existence since 2001, when the first 6 judges were appointed, and there has been a progression. Since 2001, the court started as a one-chamber court with 6 judges. Today, we have a 2-chamber court with 11 judges. The first chamber is the first instance division, and our principal judge is here, and he will probably tell you a bit more. And then there is an appellate division that is headed by the president of the court. The court, what is the main function of the court? As human beings and even as states, we realize that conflicts are an everyday possibility. So the court is there to deal with any disputes that arise in the region. And not only that, but it is to interpret and apply the treaty. The treaty is our guiding tool. And since the Democratic Republic of Congo is now a member of the East African Community, you are now obligated since July to actually comply with the treaty. And if you do not, any of your citizens or any of your enterprises operating within the country of DRC can come to the court and complain and say that you are not compliant. And if your laws, regulations, or any actions of DRC are not compliant with the treaty, there's a possibility that somebody may actually bring you before the court. Also, the court also operates as an arbitration tribunal. So if there are any agreements, any contracts that are signed between partner states, between institutions of the community, between commercial enterprises and private sector, when they have a clause that says that the court can listen to their disputes, those kind of disputes come to the court. And as the court works, it gives its decisions. It's important to know that right now there are 11 judges, and I believe when the time comes for the DRC to actually appoint a judge, we will then have 12 judges of the 2 divisions. The court works using what it calls rules of procedure, and it also has arbitration rules as well. It's important for litigants to know that to bring a case to the court, there are no court fees at all. You just come and you can, but you need to cite the breach of the treaty that is relevant. Normally the court works in quarterly sessions. By that we mean every quarter of the year there is a sitting of the court. So right now as we speak, the first instance division is actually sitting in Arusha during one of its quarterly sessions. Who can sit as a judge of the court? That's an important question the DRC needs to know. Judges are nominated, are recommended by the country. So DRC will be recommending a judge who should be a person of integrity, who is impartial, who is qualified to hold a high judicial office in the Democratic Republic of Congo. And once you recommend a judge, it is the summit, the heads of states of the East African community who appoint that person. And as we speak, the treaty allows the Democratic Republic of Congo to actually appoint a judge in the first instance division. The court is headed by the president, and he's assisted by a vice president, and both of them sit in the appellate division. And then the first instance division is headed by the principal judge, Honorable Justice Masara, who is with us, and he also has a deputy principal judge. All these judges serve for a contract term of 7 years only, or if they hit the retirement age of 70, or if they resign, or if natural causes happen and they leave this earth. So that is the term of their contract. And except the president and the principal judge, all the other judges offer their services on an ad hoc basis. That is, they come to the court during the quarterly session, and then they go back to do their other duties in their national courts. Some of them are judges, some of them are in private sector from the bar associations, but as long as the work they are doing does not conflict with their role as a judge, they continue with their services for that period. The court, the day-to-day functions of the court are run by a registrar and a deputy registrar and staff. This is the court, the first instance division, chaired by the principal judge. This is them in action. The court sits in Arusha, and they sit as a bench of 3 or 5, depending on the case. Who can bring a court to the first instance division? That's very important. According to the treaty, a partner state of the East African community can bring another partner state to the court if that partner state has not complied with treaty provisions. The Secretary General of the East African community can also bring a case to the court. But the Secretary General, before he does that, he must first write to the partner state, tell them what the problem is, wait for a response, And if whether or not the partner state responds, he will then go to the East African Community Council of Ministers, because only the Council of Ministers can give him the green light to bring a case before the court. It's a long process, and in its 20 years of existence, the Secretary General has not brought any case before the court. The other people who keep the court very busy are legal and natural persons. That is, individuals, non-state actors, non-governmental actors, commercial enterprises. These are the people who keep the court busy. And normally they come and state that there's a directive, there's a law, there's a regulation, there's an action a partner state has done or not done, so that the court looks to see whether it is compliant with the treaty. The other people who are eligible are staff of the community, and and they can also bring their cases based on their staff terms and conditions. The first instance division, all these cases that come before the court can be mediated, but mediation is an option that is given if the parties are in agreement, because it cannot be forced on the parties. Then we have the appellate division. Once the decision is made and a party is dissatisfied, they have a period of time when they can then appeal to the division. The appeal is headed by the appellate division is headed by Justice Kayobera, who is there on your left, and this is the court sitting in session. There are 5 judges. The core business of the appellate division is, of course, to hear appeals. But over and above that, the court has over the years advised the Council of Ministers when questions have arisen about treaty interpretation. And there have been a number of questions that have come. The court has also done arbitration. It's done on a number of arbitration issues. That is the appellate division judges sitting as a tribunal. And they have also offered preliminary rulings. Preliminary rulings, in summary, is if a court in the Republic or in DRC has a case before it that raises a question concerning the treaty and its interpretation, that court has the option to take that question to the court in Arusha for a ruling. We will get into these details later, so I'm just giving you an overview. The question is, who can access the court, and how do you access the court? The court is available. The main registry is in Arusha, Tanzania, but then we have sub-registries. The purpose of sub-registries is to enable litigants, East Africans, to come to file their cases without having to travel to Tanzania. So we have sub-registries in Bujumbura, Dar es Salaam, Kampala, Kigali, Nairobi. That means that if a person has a case or an enterprise or has a complaint against the country, they will go normally to the judiciary. The judiciaries of partner states have been very kind because they have given us an office, a room, and there is a person from that country who looks into the cases and they file them. The court has also invested in what they call an online case management system, which means that if you open a registry here in Kinshasa and a case is filed, the person responsible at the sub-registry will upload that case to the case management system. And almost in real time, the officers in Arusha will get to see the case. Who keeps the court busy? That pie chart there, I don't think it's too clear, but you will notice that about 96% of the cases are actually brought by legal and natural people, individuals, companies, civil society, non-state actors. And normally they come and state that the partner state has taken an action, the rules are not compliant with the treaty. As long as these people come within 30 days of the complaint, they will be heard by the court. 60 days, sorry, it's actually 60 days. They have 2 months to actually bring their complaint before the court. Anything before, after 2 months will not be heard by the court. And the main complaints we have seen over the years is that the partner states are not compliant with the fundamental and operational principles of the community concerning good governance, rule of law, concerning matters that touch on transparency and democracy. And because Article 6 of the treaty refers to the African Charter on Human and People's Rights, there are quite a number of complaints that have come that countries have breached the Charter on Human and People's Rights. The other people who keep us very busy are actually East African Legislative Assembly members. So we've also dealt with common market issues and customs union integration issues, cases, but there haven't been that many. But I will point out a few that have come to us. And employees have also and ex-employees and recruitment matters have also been dealt by the court, and there are also quite a number of them. Since about 2020, the court has actively participated in what they call e-court, which means that you can sit in Kinshasa and the court will hear you, because we have a system that we use that with the judges in Arusha, Tanzania, and with you here in Kinshasa, there is no need for your advocate or the litigant to travel to Kinshasa. And that actually saves on money, it saves on time, and it is something, it's an innovation that is very helpful to access justice. The question may be asked, what happens when the court hears a case, determines a case, what happens to the decisions? What happens thereafter? When DRC signed the treaty, acceded to the treaty and ratified the treaty, it agreed to accept all the judgments that the court will deliver. And normally what happens after hearing a case, the court will ask the partner state to take measures to implement without delay. But the court is not responsible for finding out whether the decision has been implemented. It is actually for the parties who have come to the court to follow up to tell us whether the partner state is compliant. So can the court really enforce? In a sense it can, because there's something called contempt of court. When a court gives an order, it makes a decision, and the order that it makes is not complied with, the parties can come back and say country X, country Y did not comply, or the community itself did not comply, and then the court can hear that. That has only happened in 1 or 2 cases. One of them is the Sebalu case. Also, Council of Ministers do implement the court's decisions, and in that way, integration has moved ahead. Movement of people, I just want to give you an example of a case that happened several years ago. A gentleman was arrived in Entebbe and was actually detained, not told why he was detained. He was denied entry into the country, and eventually he was deported, put on the next flight back. And he complained to the court and said, I'm an East African. Surely this country should give me access into their country as long as I have the visa, the passport, the travel document, and whatever else they require. And the country said, we're a sovereign country. We have the right to determine who will enter our country or not. This person was actually deported and labeled as persona non grata. And he came to the court and complained. And the court listened and they said, well, this particular partner state is a sovereign state, and it is entitled to actually grant access to whichever people it demands access. The treaty the common market actually guarantees East Africans free movement across the region. And they were found not to have complied, particularly with the rules of natural justice that says somebody must be told why. You must give a reason. You must follow due process before you actually deport a person. So in this way, the court has guaranteed movement within the region. Mr. Speaker, sir, the court has actually kept us very, very busy. There have been questions about the elections of members to the East African legislature. There have been questions about how the speaker can be removed. There have been questions about how the speaker can be, the process of electing the speaker. And almost every country except probably Rwanda has brought a case to the court with members complaining or people who have been unsuccessful complaining about the rules. Indeed, I can give you the example of the Republic of South Sudan. They joined the community in 2017, I believe. And within that very year, a case had been brought because the mistake they made is to nominate 9 members to the East African Legislative Assembly. And very quickly a temporary injunction was given. And fortunately, that country actually complied. I have looked at our case management system yesterday, and I realized so far there have been no cases filed against the Democratic Republic of Congo in any way. But now that you're members, just know there is the possibility that anybody in your country can bring a case. So there has been a lot of cases concerning the East African Legislative Assembly. We've also dealt with issues concerning movement of goods across the region, free movement of goods under the Customs Union and the Common Market Protocol. There have been examples of one particular case where a commercial enterprise imported goods from the from Tanzania, and they were destined for Uganda. They chose to go by road through Burundi, into Rwanda, into Uganda. When they got to Burundi, they went through the clearance process, they paid the charges, they scanned, all the custom processes that you were told about yesterday happened. And then the 6 trucks were now supposed to proceed into Rwanda, headed for Uganda. But somewhere along the line, the 6 trucks were seized by some ministry in Burundi. No reasons were given, they were detained, they were never returned. So the commercial enterprise came and complained to the court. And this particular company was actually compensated for the seizure of the 6 trucks. So this is one of the ways the court is helping the free movement of goods even within the region. As we speak, we do not know whether the damages that were awarded have actually been paid. But we do know that the court found that country in breach of the protocols that are part of the treaty. Cross-border justice, we're doing it, and it's continuing. And I'd just like to give 2 more examples. There's a company in Tanzania that produces glass products, glass products, bottles and other things. This is a very recent case. I think it happened last year. Last year, they produce in Tanzania and they export to Kenya. Kenya decided to give a 25% excise duty. And and that was found to be in breach of the community rules. Also, British East African BAT, who produce tobacco products, they also tried, Uganda tried to put excise tax, and that also was found to be in breach. I will not go into any other cases for now, but just to let you know, the court is now accessible to the citizens of East Africa, and our goal is actually to ensure that the benefits of the community actually trickle down to the citizens in the Democratic Republic of Congo. Merci beaucoup. I would give the floor to the moderator and to the principal judge should he have something to add.
Nous félicitons Madame Ruby, représentante de la Cour des issues de la CAE, pour son intervention brillante. Madame, vous avez toutes nos félicitations. Alors, ceci étant dit, je crois que nous allons suspendre le débat. Oui.
Mr. Moderator, my name is Yohani Masara. I'm the principal judge. I believe that most of the issues relating to the Court of Justice, the East African Court of Justice, have been stated by my colleague, Rubia. Only to, maybe one thing I should clarify. When she was presenting, she said the DRC is entitled to appoint one judge. That is essentially because, according to the treaty, Chapter 8, the Court of Justice has a limitation of judges. The appellate division can only have 5 judges at the same time. And right now, there are 5 judges already in the appellate division. The first instance, where I heard, there is a maximum of 10 judges, but 1 from each partner state as we speak. So the only position that is available for the DRC at the moment is at the first instance, where there is still room. We have 6 judges now, 1 from each partner state, but in the appellate division, the number is full already. So we can only get 1 person from the DRC to serve as a judge of the East African Court of Justice. And as she stated, that is not a full-time job, because unless you are a principal judge or a judge president, the court is still ad hoc. We are trying to ask the summit to allow the court to be full-time, because the number of cases have increased significantly. Like, as we speak, we have more than 176 cases pending in the first instance division. So that requires that the court becomes permanent, but as we speak, the court is ad hoc. So we expect that given the criteria given in the treaty, DRC will appoint probably a serving judge or a person of legal integrity, but who has another work, because he's not going to be permanent in Arusha. Unless there are questions, I think we end this presentation for the court. Mr. Moderator, maybe I should add that we are open to discuss with the legal fraternity here. Normally, the judges are appointed by the summit. So we have a summit coming in November. If the processes of getting a nominee of DRC can be completed by November, the summit, which will sit in November, may appoint that judge from the DRC. And all the other states the nomination comes from the head of state, the president. Normally that's the process. Of course, there are processes in the judicial service commissions where they nominate or they appoint people, send it to the president, and the president will nominate one who is going to be sent to Arusha for appointment by the summit. One more addition, Ms. Rubia told you that our sessions take place in Arusha, but we have one session outside Arusha every year. So the November session, like in this year, will be held in Uganda. Last year it was in Burundi. This year it will be in Uganda, and we rotate in all the partner states. So it is possible that one of those rotations will be here in Kinshasa or any part of the DRC. Thank you.
Merci beaucoup. Nous allons inviter l'expert de la RDC sur le même point. Madame, si vous voulez vous présenter. Pourquoi vous n'allez pas là-bas? Madame, à la tribune, s'il vous plaît. Présentez-vous. Madame, commencez par vous présenter, merci.
Merci beaucoup, Monsieur le modérateur, pour la parole. Je suis Pélagie Ebeka, je suis avocate de profession et je suis la directrice de cabinet de la ministre d'État, ministre de la Justice et garde de Sceaux. J'aimerais déjà de prime abord remercier, féliciter d'abord cette initiative, parce que j'emprunte les mots du modérateur principal qui disait que c'est comme à l'université, quand vous arrivez, vous êtes bleu et on doit vous apprendre toute la pratique, toutes les règles de jeu. Et donc, cette réunion est d'une importance capitale parce qu'elle nous permet de prendre déjà conscience de l'importance de l'acte qui a été posé par le chef de l'État, son Excellence Félix-Antoine Tshisekedi Tshilombo, président de la République, en tenant absolument à ce que la RDC devienne partie État de la Communauté d'Afrique de l'Est. Ce qui suppose que nous devrons, en tant qu'État partie, nous soumettre aux règles, à toutes les règles, et il y en a beaucoup, on s'en est rendu compte. Et donc cette réunion nous permet déjà d'entrer dans le bain, de nous habituer déjà aux différentes institutions, aux différentes normes de la communauté. Et en ce qui concerne la Cour de justice, nous avons suivi avec attention la présentation et nous avons retenu beaucoup de choses. L'organisation de la Cour, qui a vraiment une certaine particularité, parce qu'elle a deux instances, c'est-à-dire une juridiction de première instance et une juridiction de seconde instance d'appel. Et donc c'est déjà une particularité. Nous avons aussi retenu le fonctionnement de la Cour, la jurisprudence de la Cour, les conditions d'accès à la Cour, et cela nous a énormément édifiés. Et le point le plus important pour nous aujourd'hui, en tant que ministère de la Justice, c'est de considérer que la République démocratique du Congo, en tant qu'État partie, devra nécessairement désigner son représentant à la Cour de justice. Et comme on vient de nous le dire, le sommet des chefs d'État qui doit nommer ce juge se tiendra au mois de novembre, et donc il ne nous reste que très peu de jours pour nous organiser quant à ce. Et donc c'est la raison pour laquelle nous estimons que nous pourrons valablement demander, n'est-ce pas, à l'organisation de la Communauté d'Afrique de l'Est de faire en sorte que nous puissions rapidement organiser des réunions, soit à Kinshasa, soit au siège, pour pouvoir vraiment que la communauté puisse nous appuyer par rapport à tous les aspects, mais pour ce qui concerne les aspects justice, nous avons, en tout cas la RDC, nous aurons vraiment besoin de l'accompagnement de la communauté parce que, comme vous le savez, tous les juristes le savent, nous n'avons pas avec les autres partis, en tout cas la plupart des États membres, le même système juridique, le même système judiciaire. Et nous, RDC, nous devrions justement fournir beaucoup d'efforts pour nous adapter au système de la Cour de justice de la Communauté d'Afrique de l'Est. Je voudrais juste, avant de terminer, répéter, donc revenir sur ce besoin-là que nous avons d'organiser des réunions très rapidement, des séances non seulement de renforcement de capacité, mais surtout pour continuer à discuter de la meilleure manière selon laquelle la RDC pourra procéder à la désignation du juge qui devra siéger à la Cour de justice de la Communauté d'Afrique de l'Est. Pour le reste, je crois que nous nous en remettons à l'organisation et nous espérons vraiment très, très vivement que ces séances de travail, ces réunions-là, auront lieu incessamment pour nous permettre de nous organiser à l'interne. J'ai dit, je vous remercie.
Merci beaucoup, madame. Voilà, c'est la réponse congolaise à cette question-là. Nous allons nous réunir pour voir comment nous devons harmoniser notre système judiciaire avec celui de la communauté de l'Afrique de l'Est. Alors, ceci étant dit, j'aurais souhaité qu'on passe au jeu de questions-réponses, mais je crois qu'il y a encore d'autres exposés. Alors, si vous pouvez, si nous pouvons nous convenir pour prendre le petit repas maintenant, de manière qu'après, nous puissions revenir pour continuer le travail. Alors, je reviens, il y a des personnes qui ont exposé, qui s'en vont, notamment la présentation numéro 6 et 7, je crois, 6 et 7. Alors, s'il y a des questions, nous les posons de manière que nos amis les soient libérés. Et nous nous sommes convenus à 2 questions pour compte tenu du temps qui passe. 2 questions s'il y en a. Apparemment, il n'y en a pas. On ne va pas. Mais aux intervenants, aux ceux qui ont exposé. Oui, allez-y. Il y a madame qui venait d'être là. L'honorable président du Parlement est parti. Il y a madame Kiroubier qui est encore là. Et je crois que c'est ça. Il y a 2 femmes. Oui, c'est ça.
S'il vous plaît, monsieur le modérateur.
Oui.
Avec votre autorisation, toujours en regardant mon calendrier, je reste un peu conformiste. Je regarde mon heure, il est 14h20, alors que la pause déjeuner devrait intervenir à 13h30. Je vous propose, monsieur le modérateur, que nous puissions prendre la pause déjeuner et que les questions viendront juste après la pause déjeuner.
On les pose parce que ces personnes vont partir. C'est ça la raison. Elles vont partir. Bon,
je m'incline alors.
De toutes les façons, j'ai constaté qu'il n'y a pas de questions. Mais il faut lever la main. Voilà, vous allez là-bas. Merci, allez poser des questions. Deux questions seulement. Chacun peut poser 10. Il faut désigner la personne à qui vous posez la question.
Oui, je désigne. La première question que je pose à M. Stéphane, qui a parlé de marché commun.
Ce n'est pas simple.
Je voudrais qu'il nous dise s'il y a des dispositions dans la charte qui permettent de sanctionner un État récalcitrant, un État qui ne se conforme pas aux dispositions de la charte. Mais également savoir, est-ce que les États ont la liberté de se retirer de la communauté lorsqu'ils se trouvent dans une situation telle que leurs intérêts ne sont pas garantis? Ça sera les deux premières questions. Mon collègue de l'Assemblée législative, je voudrais savoir quel est le quorum de décision. Est-ce que ce sont les États qui... Je ne sais pas comment vous évaluez le quorum de décision à cette Assemblée législative. Est-ce que par majorité ou les États se concertent pour prendre des décisions? Je veux savoir si l'Assemblée législative a combien de sessions, mais également le contrôle parlementaire effectué, il est fait à l'égard de quel pouvoir exécutif. Est-ce que ce sont les exécutifs nationaux ou c'est l'exécutif au niveau de la région? Voilà, madame qui a parlé de la justice, elle a estimé que les décisions sont exécutées par les États partis. Et lorsque celui qui a saisi la justice au niveau régional se réalise que la décision rendue en sa faveur n'est pas exécutée par l'État, il peut encore repartir au niveau de la cour régionale. Je me dis que la plupart des décisions ne seront pas exécutées. Prenons l'exemple où je me trouve en contradiction avec mon pays. Et vous désignez mon propre pays qui est en contradiction avec moi comme celui qui est chargé d'exécuter les décisions rendues par la Cour régionale. Vous ne voyez pas que moi, justiciable, ou moi, qui ai saisi la justice au niveau de la région, je risque de ne pas voir la décision rendue à ma faveur être exécutée. Merci.
Vous avez posé deux questions. La première a trait au marché commun, elle n'est pas concernée par la série de questions que nous devons poser maintenant. Néanmoins, je crois que M. Stéphane a noté, il pourra vous répondre plus tard, puisque lui n'est pas concerné. Mais en attendant, je demande à Madame Rubia. C'était vous? Voilà, allez-y, répondez à la deuxième question. Okay.
Merci beaucoup, monsieur le modérateur. J'ai une préoccupation qui est liée à la multi-appartenance des pays aux communautés économiques régionales. Et cela n'épargne aucun État membre de l'Afrique de l'Est. Donc chaque État est au moins membre de plus d'une communauté. Alors c'est ce qui pose problème. Vous savez que ces communautés, au niveau régional, sont appelées, au niveau sous-régional, sont appelées à coopérer de manière à harmoniser leurs politiques et programmes en vue de l'intégration économique africaine, conformément au traité d'Abuja créant la Communauté économique africaine. Maintenant qu'il est demandé à la RDC d'être membre du marché commun de l'EAC, cela pose un peu problème parce que c'est faisant, la RDC qui est aussi membre de la SADC, membre du COMESA et membre de la CAC, ne pourra plus jamais adhérer ni à la zone de libre-échange du COMESA, de la CAC et de la SADC, et moins encore à l'union douanière de ces communautés-là, puisqu'elle aura déjà adhéré au marché commun de l'EAC. Alors, comme l'Union africaine a exhorté les États membres les communautés, les différentes communautés, il y en a 8 communautés économiques régionales qui sont appelées à piloter l'agenda de l'intégration africaine. Parmi ces communautés, c'est aussi l'EAC. Et on demande à toutes ces communautés d'harmoniser leurs politiques et programmes pour cet objectif-là de l'intégration africaine. Alors, je suis en train de me poser maintenant la question. Je dis, est-ce que au niveau de l'EAC, il y a une stratégie concernant cette harmonisation des programmes et politiques pour parvenir à l'objectif au niveau continental? Donc, c'est ça. Puis, je sais déjà qu'on a commencé. Donc, il y a la tripartite EAC, COMESA et SADC, ce qu'on appelle le forum commercial de négociation tripartite. C'est pour harmoniser justement ces politiques-là, mais au niveau d'abord des 3 sœurs. Alors, je suis en train de me demander, comme déjà nous sommes, nous RDC, membres du forum commercial tripartite EAC, SADC et COMESA, si, par exemple, on ne peut pas aussi avoir l'idée d'harmoniser avec la CAC dont nous sommes membres. Je vous remercie.
Je crois qu'il y a eu quiproquo. La première personne qui vous a précédé a posé 2 questions. Dans ces 2 questions, il y a une qui revient à Mme Roubia. Oui. La première, c'est pour M. Stéphane. J'ai dit, pour Stéphane, comme il ne parle pas, on répondra après le repas. Alors, j'ai pris aussi, M. Stéphane, de noter votre question, oui, parce que là-bas, nous sommes dans des cercles concentriques. C'est ce dont rêvait Senghor. Senghor voulait que l'intégration se fasse par des cercles concentriques. Nkrumah, lui, voulait une union immédiate. Bon, nous tous, on va vers l'union immédiate, mais vous posez une question de transition. Qu'est-ce qu'on va faire pendant le période transitoire? Parce que l'agenda, c'est 2030. Alors, il pourrait vous répondre. Monsieur Stéphane va vous répondre après le repas.
Oui, merci.
Mais est-ce que Mme Roubia peut répondre à la première question? Madame Roubia, vous aviez noté? Ah, ok.
Thank you, Mr. Moderator. I think the question was relating to enforcement of judgments, if I got you correctly. As we speak, most of our decisions are declaratory. Declaratory in the sense that someone comes to court and says, country X has violated the treaty. So they're asking the court to decide or to make a declaration that maybe DRC or Tanzania or Uganda has violated certain rights of certain individuals or groups of people, and the court will declare that country X has violated. So it's not so easy to measure enforcement of that decision. But when the court declares that you have violated certain rights, it is expected that the law or the action that we have declared to be violative of the treaty will not be repeated. So that's one. But where a certain person wants certain damages or some payments because of such violation, we also declare. We also give certain reparations. The court is empowered to give reparation. The court is empowered to give damages. And we have so far made a number of decisions, and countries have complied. The compliance rate is more than 76% as we speak. So a country feels so shameful if it does not comply with the organ that it has agreed to establish itself. Because the community is made of three main organs. The executive, led by the Secretary General, the Legislative Assembly, led by the Speaker, and the court. So when the court decides, that becomes a decision binding on that particular state. And we are happy that there have been very few occasions of non-compliance, but compliance rate is very high. I think that's what I can say. Maybe something to add. When DRC became a member of the East African Community, the treaty at the same time opened the door for any person who will allege that you have violated the treaty provisions. Of course, we have time limitation that only 60 days, so you cannot bring matters that happened 5 or 4 months before. But when you become a member, when you became members, full members in July 2022, 60 days thereafter, a person can bring an action against DRC. Normally, actions are brought against the Attorney General or the Minister of Justice of that country. So the Minister or the Ministry of Justice of DRC will be responsible to respond to all the claims or references or actions brought against DRC. And we have very strict rules. We have rules of procedure that once a claim has been filed against a particular state, that claim has to be served to the Office of the Attorney General, and it has to be responded to within 45 days. So if you violate those rules, there are consequences against it. I hope I've answered the question. Thank you. And we thank you, the Democratic Republic of Congo, for listening to us and for giving us the opportunity to explain. And we are ready, as requested, that at any particular time, we are ready to discuss with the Ministry of Justice, with the Office of the President, or with the Foreign Affairs on any matter that may still be outstanding. Thank you.
Merci beaucoup. Je crois que nous pouvons suspendre les travaux pour nous faire la santé. Bon appétit. Un peu rapidement parce que
Merci. Pour le temps, nous invitons le
membres sont aussi appelés à suivre les orientations du protocole pour prendre l'heure déjeuner. Il s'agit de l'honorable président de l'Assemblée législative, Monsieur le président de la Cour de justice, Monsieur Jean Bosco Kalissa, Madame Amélie Ningozé, Monsieur Koka, Monsieur le général François Mwamba, oui, Monsieur le conseiller principal Désiré Mouala, Madame conseiller principal Bola, Madame Ebeka et Monsieur le conseiller principal de ce Premier ministre, Monsieur Dio Moland. Le protocole a été sous personnalité pour leur repas.